Well, it's not over just yet, it seems, for former President Jacob Zuma. So what's the legal fight that lies ahead for his team? Zuma is going back to the Constitutional Court with an application to rescind the order that he be sent to prison. He is relying on Rule 42 of the Uniform Rules of Court. This allows for a variation or a rescission of an order of the country. Well, does Zuma's case meet those requirements? Let's find out now. We chat to eNCA's Barry Bateman. Barry, Zuma has filed, as we know, two separate applications, one in the High Court for a stay of the Constitutional Court order. What are the details there?
Well, in the stay application, Uveka, this is relying on, as you've just touched it on there, Rule 42 of the Uniform Rules of Court, read together with the rules of the Constitutional Court. And essentially what he's had to do here is to the requirements for him to be able to file this application is that he'd have to show the court that he wasn't given a fair opportunity to present his case. Alternatively, he'd have to show the court that there's been a grave misdirection of the law. But on that first point, which is what he's attacking here, claiming that he had not been given a fair opportunity to present the case, he's certainly skating on thin ice. You would have recalled he was given that opportunity before he was sentenced. It was in April that there was a hearing of the Constitutional Court. He was asked to please present mitigating factors or argument in the event that the court finds him guilty of contempt of court. So his argument to claim that he was not given a fair opportunity is going to be a bit difficult to fly. So it's on that grounds that he's going to be bringing this application. But I'm going to move across to this other application, which is going to be in the High Court. Now, that is got two legs in itself as well. There's a Part A and there's a Part B. Part A of that application is for a stay. He wants the execution of the constitutional order to be halted until such time that the rescinding application is heard. But he sits with a difficulty there. You're dealing with a lower court, which is the High Court in Pietermaritzburg, and he's asking that court to stay in order of the Constitutional Court. I've spoken to some legal expert, and the point they make is that this upends the principle of precedence as well as the hierarchy of the courts in South Africa. But I asked attorney Ulrich Roux about his prospects of success, or Zuma's prospects of success, and he had this to say.
That is flawed from the outset, in my opinion. The High Court in Pietermaritzburg cannot make an order to say that a constitutional court order should be stayed. It simply does not have the jurisdiction to do so. As we all know, the Constitutional Court is the highest court in our country. It is regarded as the apex court. It is the custodian of our Constitution. And any court must adhere to a Constitutional Court order, and any law or order which is in contradiction with the Constitution must be seen as being invalid. So simply put, I do not see there being any merit in the application.
So, Barry, the former president also approaching the Constitutional Court to rescind the order that he actually go to jail. So what are the requirements for an order to actually be rescinded? And does Jacob Zuma meet those requirements?
Yeah, again, say it's a difficult ask. The president was given ample opportunity in the run-up to where we find ourselves today to make representations to the Constitutional Court. And he argues in his papers that, he says now at this stage that the reason that he did not make any submissions in this Constitutional Court application was because he was having severe financial constraints, that he was picking his legal battles very carefully, and he was under the impression, either ill-advised or not, that the court would simply not entertain the particular matter. Nevertheless, he simply did not make any of those submissions as required, as asked to by the courts. Now, the requirements in terms of the various rules for him to be able to bring this application, he'd have to show that he wasn't given a fair opportunity to make representations to the court. And as I've just discussed here, it does appear that he's going to have a very difficult time convincing the court. And even if you just look at the judgment on Tuesday, the court was mindful of what the president was doing. Instead of engaging with the court, on that day he was asked to provide mitigating submissions on mitigation of sentence. He instead sent a letter, a 22-page letter to Chief Justice Mogoeng, where he referred to the bench playing political gimmicks. So he'd rather have a dig at the bench from that direction instead of filing an application. So it doesn't appear that he's going to have much legs to stand on in that particular leg of the application. Now, I was speaking to former academic and now practicing advocate James Grant on what he thinks is going to take place in the next coming days. Take a listen.
I don't believe that the Pietermaritzburg High Court has the authority to stay the Constitutional Court order, and therefore the Commissioner of Police is under an obligation to take Mr. Zuma into custody and deliver him to Westville. And I believe that the Commissioner is in the absence of a stay from the Pietermaritzburg High Court, which, as I've said, I don't see happening. I foresee the Commissioner dispatching police members to go and apprehend Mr. Zuma. I can only hope that that ends without bloodshed.